What are some weird marriage laws in the USA? In the United States, marriage laws can be strange and sometimes downright bizarre. Just yesterday, discussions about unusual marriage laws gained traction online. Many people are curious about what these laws entail and how they affect couples today. Let's take a look at some of the weirdest marriage laws across the country that you might find surprising. In Alabama, it is illegal for a couple to marry if either person is considered a habitual drunkard. This term is subjective and can lead to confusion. Meanwhile, Alaska has a law that once prohibited marriage if either person was deemed mentally incompetent. The definitions surrounding this can be quite peculiar. In Arizona, the law states that a couple cannot marry if one partner is under the age of 15. However, those aged 16 or 17 can marry with parental consent, leading to some unusual situations. Arkansas has a law that forbids a man from marrying his deceased wife's sister, which seems outdated today. California's marriage laws include a ban on marrying if either party is classified as an idiot or lunatic. These terms are outdated but still appear in legal language. Connecticut does not allow marriage between first cousins, which is uncommon in many states. In Florida, a marriage license becomes invalid if the couple is related within the third degree of consanguinity, but the specifics can be confusing. Georgia had a law that prohibited interracial marriage, which has since been repealed but remains a historical oddity. Idaho requires couples to undergo a blood test before marriage, a requirement that has been dropped by many other states. Iowa prohibits marriage if either party is considered mentally incompetent, similar to several other states. Kentucky has a law that forbids a woman from marrying if she is pregnant by another man. This law is rarely enforced but still exists. Louisiana requires a 72-hour waiting period after applying for a marriage license, which can feel excessive compared to other states. In Maine, marriage between first cousins is allowed, which is unusual compared to many states. Maryland prohibits marriage if either party is under 16 but allows those aged 16 or 17 to marry with parental consent and judicial approval. Massachusetts requires a blood test for syphilis before marriage, a law that many states have since repealed. Michigan, like Arkansas, does not allow a man to marry his deceased wife's sister. Mississippi forbids marriage between first cousins, but allows it if both parties are over 65. Missouri requires a blood test for certain diseases before marriage. Montana has similar restrictions regarding mental competency. Nebraska also prohibits a man from marrying his deceased wife's sister, an old law that remains on the books. Nevada is known for its quick marriage process, but forbids marriage for those under 18 without parental consent. New Hampshire allows marriage at 16 with parental consent, while New Jersey has a 72-hour waiting period after applying for a license. New Mexico allows marriage at 16 with parental consent as well. New York forbids marriage if either party is considered mentally incompetent. In North Carolina, a man cannot marry his deceased wife's sister. Ohio prohibits marriage if either party is under 18 without parental consent. Oklahoma has similar restrictions regarding mental competency. Oregon requires a 3-day waiting period after applying for a marriage license. Pennsylvania also prohibits marriage if either party is under 18 without parental consent. South Carolina has laws against marriage if either party is mentally incompetent. South Dakota requires a blood test for syphilis, while Tennessee has similar restrictions. Texas mandates a 72-hour waiting period after applying for a marriage license. Utah prohibits marriage if either party is mentally incompetent. Vermont allows marriage at 16 with parental consent. Virginia has similar restrictions regarding mental competency. Washington requires a 3-day waiting period after applying for a marriage license. West Virginia also forbids marriage if either party is mentally incompetent. Wisconsin has a 6-day waiting period after applying for a marriage license, while Wyoming prohibits marriage if either party is mentally incompetent. These laws reflected old social norms or medical concerns, and while many states have updated their regulations, some quirky rules remain.